Get ready for the dictation. Start. Matter pertains to appointment to the post of Deputy Director Law in the other backward class category. Appointments to the vacancies in the aforesaid post were to be made in the office of Competition Commission of India. The three appellants in these three appeals were also the candidates who appeared in the written test. After qualifying the written test, they also faced the interview. However, their names did not appear in the list of candidates finally selected. According to the appellants, their non-selection was the result of altering the prescribed mode of selection midway, that is after the initiation of recruitment process, which was impermissible. This contention has not found favor with either the learned single judge in the writ petitions filed by them or the division bench of the High Court in the appeals filed by them challenging the order of the learned single judge. Bone of contention before us also remains the same. Therefore, the issue which needs to be decided is as to whether there was any change in the mode of selection after the process of selection had started. CCI had issued the notification through public notice inviting applications for various posts. We are concerned with the post of Deputy Director Law, for which 13 vacancies were. Clause 7 of the notification stipulated the mode of selection in the following manner: all the applications received by the due date will be screened with reference to the minimum qualification criteria. From amongst the eligible candidates, suitable candidates will be shortlisted through a transparent mechanism, and the shortlisted candidates will be called for interview before final selection. Mere fulfilling of minimum qualification by itself would not entitle any applicant for being called for interview. The eligibility, qualification, experience required for this post was also provided in the advertisement. It is undisputed that the appellants fulfilled the eligibility condition, being holder of degree of Bachelor of Law professional as well as 3 years experience in the relevant field including in the corporate sector. Written test for this post was held on for short listing of candidates for interview. Admit card was also issued to the appellants for appearing in the written test along with the detailed instructions including the scheme of examination. Paragraphs 4 and 9 of the instruction which were given to the examinees candidates are relevant for our purposes, and therefore we reproduce the same hereunder. The selection to all the positions advertised will be based on a written test followed by an interview of candidates. Written test will carry 80% of the marks and interview will have 20% of the marks. The written test will be in two parts. The first part will be based on multiple choice questions for 50 marks. There is no negative marking in this multiple choice questions. The second part, carrying 30 marks, will be distributed to the descriptive questions on the subject of your specialization within the broad outline of the subject of specialization as indicated in the advertisement. Candidates who do not secure 50% of the marks in the test will not be called for the interview. However, for candidates belonging to the reserved categories, the cutoff marks will be 40% of the total marks. Written examination was of 80 marks and the appellants secured more than 50% marks therein. They were called for the interview, which was held on 19th March 2010 and the result of which was published on the website of the CCI. Finally, only 5 candidates, that too from the general category, were selected. Nobody from the OBC category, to which category the appellants belonged, emerged successful. On obtaining the information from the respondents under the Right to Information Act 2005, the appellant came to know that he had secured only 2 marks out of 20 marks in the interview. In this manner, total marks secured by him were 53 out of 100 marks. He also learned that the respondents had fixed the benchmark of 70 marks for the general category and 65 marks for the reserved category candidates. Since the total marks obtained by all these appellants were less than 65, that was the reason for their non-selection. It is this fixation of benchmark which has agitated the appellants, and according to them, it amounts to changing the selection procedure midway, which is illegal. The appellants approached the High Court of Delhi by filing a writ petitions challenging their non-selection primarily on the ground that the selection criteria was changed arbitrarily, that too after the advertisement, and the law did not permit the respondents to change the rules of the game after the game had started. The precise contention in this behalf was that the benchmark, which was fixed at 70 and 65 marks or above in the general and reserved category respectively, for the purposes of selection, was not mentioned earlier, that is, before the start of selection process, either in the advertisement or otherwise. The writ petitions were contested by the respondents.